All right, we are recording. So I'm going to start, as I always do, with 1 minute worth of administrative talk. First of all, of course, thank you everyone for participating on the forum. It means a lot to me, and I think we're all getting a lot out of it, which is really awesome. We've had some great speakers so far. Our first speaker was David Feld. I don't know if you guys caught his new build discussion, but there's a lot of speakers like that we're going to line up who are industry professionals, the best of the best. And if you guys have anything particular that you want to listen to, please let me know. I also want to acknowledge, I guess, a birthday of sorts. I guess it's not a birthday, but it's a numerical birthday. We've reached, or we're about to reach today, 1,500 people on our forum. That's an awesome number, and it comes with a responsibility to fundamentally ensure that we continue to raise the bar in terms of legal education. And make sure that we are all getting a lot out of it. Every hour you guys devote to this forum is an hour that you could be doing something else, so we have to make it worthwhile, and I thank you all for your time. All right, let me share screen, and let's get started, because though you like hearing me blab on, you like learning more. Can people just please confirm for me for a second that they are now seeing what I have on my screen?
Yep, I see your screen.
Perfect. Okay. So let's get cracking, guys. We're going to start. Gail raised her hand. I guess Gail was just acknowledging that she sees my screen. All right. So if you need to speak, if you have any questions, Gail, just raise your hand again. Or if anyone needs to, because I think we're going to be a fairly large group today, if you need to ask a question, just raise your hand using Zoom. I have it up here and I will see it. So real estate and family law, quote of the day. To those who say real estate is the biggest financial decision one will ever make, I say, have you ever tried to get divorced? Now, this isn't actually a quote from somebody. This is just something I made up. But having said that, I do see a whole swath of people. Yeah, perfect. Thank you, Gail. I see a whole swath of people who are in divorces, and my God, that is probably the most expensive thing you will do in your life, well in excess of buying a house. Separate and apart from the financial advantage and obviously problems, you know, the emotional toil and everything that goes along with it is real. And so just obviously, you know, be advised. I don't need to tell you this. You guys all know people who've been divorced. You've been divorced yourself, and you know that what I'm saying is true. So let's talk about the basics first. And the way I'm going to structure today's talk about family law is tell you what the law is without any intervention by the family law, and then tell you how family law alters what it is you know about real estate. So in the normal course of things, if we were just living in the law of the land, and you know, there was no concept of marriage or anything else, then ownership of property allows the person who owns that property to do a variety of things. And this will bring you back to your OREA course, where we were talking about the 6 primary uses of a fee simple, or any fee for that matter. You have the right to use your property, you have the right to sell your property, to lease your property, enter a property, give a property away, not do anything else with the property. And what's more, when you die, your estate takes on your property. And critically to this understanding of owning anything, because when I say property, I'm not just talking about real estate, I'm talking about anything. Critical to the understanding of ownership of any property is the idea that your ownership precludes anyone else from having an ownership interest. So in the normal course of things, when Mark Morris puts his name on title to anything, Mark Morris exclusively has rights to that thing, and no one else has rights to that. And I can do any of the things mentioned here once I have ownership. But family law specifically changes that dynamic. And it changes that dynamic as regards to all property, but real estate specifically. Today's talk is about the way that family law changes the dynamic of ownership, which otherwise would give you exclusive use to use property in
I
the.
went over to Christine's house.
Sorry, I'm just going to mute you.
Her mother-in-law there, her two little.
Okay. Which otherwise would give you exclusive use to a property for which other people would not have recourse. So let's talk about the state of affairs in Ontario. So it was the case that it used to be the case, at least, that there was a common law principle called the Dowers Act. And what that was one partner in a marriage, traditionally a woman, would come in with very few assets. Remember, this was before the 1970s at this point. Would come in with very few assets. And a husband, upon owning a house or owning whatever it is, because there was no Family Law Act that was in place, technically, absent the common law, could go ahead, get remarried, do what he wanted with the asset or leave it to kids. And so the common law stepped in and said, no, fundamentally there is a common law right, a dower's right, to stay and use a property for the given lifetime of that person. So that if husband passes away, leaves everything to their kids or to a mistress or anything else. Again, I'm talking in very gender construct manner, but I'm also referring to a time before the 1970s. Not that it's, not that there aren't problems today, but fundamentally what would happen is generally a wife would be able to rely on her dower's rights in the event that she had been disinherited through a will or anything else, which is equivalent to what we call the spousal right of possession today. That is to say, they could sit there, bum down, and not give up use of the property until such time as they died. That didn't really do much for equality. I mean, sure, it kept spouses in their homes until their death. But if you think about it, particularly after the 1960s, as more and more people entered the workforce, but more importantly, as there was a recognition that people's work at home was as valuable, if not more valuable, than work in the workplace and raising a family. And more importantly, as there was a recognition that working at home necessarily meant that you were giving up opportunities to earn income in a marketplace, the Ontario legislature got involved. And they passed the Family Law Act. And the Family Law Act is predicated upon the idea that all people who engage in a marriage engage in an equal partnership. Now, listen to what I'm saying. All people who enter into a marriage engage in an equal partnership during that time. And that time is critical. Merely being married to someone does not mean that you get their stuff or that you own half their stuff. Because the only equality that you actually see in Ontario is an equality that is predicated upon at the time of marriage. Sorry, guys, there's some background noise, and I just ask you to all mute your screens if you don't mind. Oh, Maggie, it's you. I'll just mute you. There you go. So there is, of course, the idea that marriage is equal. The time when you are married needs to be equal because you are contributing to a household, and the fact that you are working, say, in the house means that your spouse is able to go out and earn a living. It therefore makes sense that fundamentally anything that has been earned during the time you have been married should be divided up equally. But this does not pertain to times after marriage or to times before marriage. It does, however, mean that each spouse is entitled to an equal share of the family assets and debts accumulated during the marriage. Until separation, everyone owns what they own. So to be clear, let me go into this. Under the Ontario Family Law Act, everyone, a unit of people who enter into a marriage are to be treated equally and are, upon the dissolution of that marriage, to divide out what that marriage period has contributed to their joint assets. That needs to be divided equally. Anything that any of the individuals have come into the marriage with, not applicable, with certain exceptions that we'll talk about. Anything that someone earns after, not necessarily applicable. And while you are married, you do not own any of your spouse's assets either. In fact, the only time that you in a marriage get access, legal access and rights to your spouse's assets are upon separation and equalization. Let's talk a bit about that. So let's use partner A and partner B. You'll see that in this instance, partner A is bringing $260,000, sorry, $60,000 into the marriage. So they have a bank account with $60,000 in it. Let's think about that. Partner B is bringing $90,000 into the marriage. Could be, I don't know, a bank account with $60,000 and $30,000 worth of art. Whatever it is, their assets, subtracting their debt, equal a net amount that they are bringing into the marriage. Partner A brings in 60, partner B brings in 90. During marriage, partner A accumulates, it's not how much they make in income, no one cares about that, accumulates $260,000 worth of assets, and partner B accumulates $40,000 in assets. And post-marriage, so they get divorced, separated and divorced, partner A is able to get another $110,000 worth of assets assembled, and partner B makes $3.1 million in assets. So you'll see that I've divided it up into 3 stages: stage 1, stage 2, stage 3. The only time that partner A and partner B have to reconcile and ensure that there is equality is at this point, at the end of the marriage. And at that time, the only relevant consideration is not what was brought into the marriage and not what they make after the marriage, but rather while they were a single unit, what their combined assets were. So in this instance, from the day they got married to the day they got separated, they actually made a combined $300,000. Meaning that each of them should be walking away with $150,000. This is called the equalization discussion. In order to get $150,000, partner B only has $40,000, and therefore partner A needs to pay $90,000 to partner B, meaning that both of them will then have $150,000. Note, we are not equalizing for this amount. This has nothing to do with anything. We are not equalizing for this amount. That has nothing to do with the equalization period either. And if you think about it, how is this an exception to property? Well, because under the normal rules of property, if you own something, you own something. If I own $260,000, that's my $260,000. No one has a right, but the Family Law Act says no. What you take ownership during a marriage is not yours exclusively upon separation. It must be shared. It's the first exception that the Family Law Act creates to how property is held. I'm going to pause for a second. Does everyone understand that? Generally, I haven't talked about marital homes yet. I know some people are going to talk about that, but does everyone understand that so far? I'm going to take it from your silence, because there's quite a few participants here, that everyone gets it. Oh, sorry, Kathy wrote, why 90,000? Why not 110? Well, the reason is because, Maggie, the whole combined asset is $300,000. Of that, presently, so there's $300,000 to play with. Of that, partner A already has $260,000. So if both parties need to end up with 150, because that's how much money we are total, the couple has been able to total together while married, if each side needs 150, and this person, oh, I'm sorry, you're correct. You're correct. You're saying I did the math wrong, and you're right. I probably should have looked that in. You're correct. It's $110,000 that needs to be paid. Thank you, Kathy. You're absolutely correct about that. Sorry if that was confusing to people. This is what happens when you do a presentation early in the morning and don't double check your work. So what can I tell you? You guys have said you want 10 o'clock in the morning. You have to take morning mark. That's all there is to it. Thank you for pointing that out, Kathy. You're absolutely right. All right. What I want to point out is there are certain assets that you get during the course of a marriage which do not factor into this equalization breakdown as well, just so you are aware. These include inheritance, because if mom and dad are giving you money or they die or whatever it may be, it's not included as part of what the couples together got. If you think about it, partner A would have gotten that absent partner B being there regardless. Court orders, you want to know why court orders? The average marriage in Ontario takes how long? How long do you think? Average marriage in Ontario is 7 years. That's what it is, or 7.5 years or something. For people who get divorced, by the way, not if you're taking of all the people who get divorced, so 50% of the population, that is 50% of the people who are getting married and are going to get divorced, the average person gets divorced in 7 years. If you think about it, how long does a court case take? Well, it takes significantly more than 7 years. And what that means is that most court orders and money that stem from court orders are coming from a time where the tort or the contractual wrong or anything else is probably taking place prior to the marriage in any event. So court orders are excluded. Gifts are excluded, and insurance payments are excluded. And so the numbers here, 260 and 40, are things that family lawyers will argue about, and they'll say, yeah, he definitely has $500,000 in his bank account, but of that, fully $240,000 of that came from an inheritance, so really the net family property does not include that $240,000. All he has to contribute is $260, therefore the total assets are $300. That's the way that works. Does that all make sense? And Crimson Rose is writing that perhaps 7 years is too long to be married and before getting divorced. I will leave that without comment. All right, now let's continue this discussion and bring it a bit towards real estate. So let's take a scenario where we have partner A, and I'll check if the math is right here, because if I was wrong on the Ross page, I might be wrong here. I'll look at it with a fine-tooth comb. Here, we're going to have a scenario where partner A brings $60,000 into the marriage, and partner B brings $90,000. But unlike before, where partner B brought $90,000 in the form of art and a bank account, the $90,000 that partner B is now bringing is going to be in the form of a house. It is a house that during the course of marriage, both parties are going to live in. In this instance, the same amount of money is generated during the course of marriage, $260,000 and $40,000, meaning $300,000. But there is another exception in the Family Law Act. The Family Law Act states that if a home is brought into the marriage by one of the partners, the value of the house prior to marriage is included in the net family property. So whereas before, the value of the property, of the marriage property, was $260 plus $40 equals $300, now the value of the property is $260 plus $40 plus $90,000, because this wasn't just cash in a bank account, this was the matrimonial home. $390 divided by 2 is now $195, and now party B, who has $65,000, sorry, hold on a second. So, sorry about this. Party B needs $195,000, that's correct, and has $130, that's correct, because he is 90 plus 40. I'm making sure this is right. Therefore, partner A now needs to contribute. This is wrong still. That does not total. Wow, I don't know what the hell was going on. B, $65,000, right? Thank you again, Kathy. Oh, see, there you go. Look at that. You're helping me out already. There we go. Again, morning. I'm counting it off. So party B now needs to pay partner A now needs to pay partner B $65,000, significantly less than partner A had to pay partner B before, all because partner B's assets happen to be a marital home. And this brings us to the second exception to property. Because, as we discussed, under the normal rules of property, if you have your ownership on the property, you have the right to sell the property and not do anything with the property, not give it away or anything else. It's one of the bundles of uses. But when you are dealing with a matrimonial home, despite the fact that this person is the only person on title, and it will not change throughout this, the value of that property is included in the net equalization payments. Note, at no time does partner A go on title. At no time does partner A obtain the rights to the property. They obtain the rights to the value of the property. It's a significant difference. But regardless, the second marital exception pursuant to the Family Law Act is that the value of what you take ownership of during marriage is not yours exclusively, and marital homes owned before marriage are not yours exclusively. Again, they are yours on title, but the value of the property is not yours exclusively. All right. Let's talk about the third exception that the Family Law Act. I'm going to pause for a second. Does anyone have any questions with regards to this first before I move on? No, we're good. I take it from your unanimous silence that we are good. Bringing the home into the marriage, says Ashley. Sorry, I'm just waiting for Ashley to write a question. What does bringing the home into the marriage mean? Okay, we are going to talk about that. So what Ashley is asking me is, what does it mean to be a matrimonial home? And that brings us to the next slide. So the matrimonial home is confused by real estate. Oh, hold on. Tracy wants to know, sorry, I'm just going to go back, guys. I'm sorry for those people who are recording, but I'm trying to answer questions as I go. Where is the 130 coming from? The 130 comes because what we've done is this. We've taken 260 plus 4. We tried to determine what the net family property is. The net family property consists of 260 plus 40 plus 90. Because this marital home, this 90,000 was the value of the house, the price of the house, if you will, minus the debt that was in the house, the equity in the home that became the marital home. So the 130 comes by adding all this up. Sorry, you're asking where's the 130 coming from? I'm sorry. I'm just trying to figure out, 195 and has 130. So this 130 comes from the 40 plus 90 because we're trying to figure out what partner A has, which is 260, and partner B, in this case, doesn't have 40. They have 40 plus 90, and therefore 130. Does that make sense? Okay, good. So let's move on. The marital home right. Agents are continually confused with the difference between a tax term, which is the principal residence, and the matrimonial home. The principal residence, or the primary residence, is something that one couple can have per year. So you may own 4 homes as a couple, or let's be a bit more average. You may own 2 homes as a couple, a cottage and a house. As a couple, only one of them can be your primary residence and thus free of paying capital gains. That has nothing to do with a matrimonial home. A matrimonial home is a place where a couple's underwear ordinarily resides. It may be that you have a house, a cottage, and a villa in Tuscany, all of which you use regularly. All of those are matrimonial homes. All of them are assets that the couple ordinarily reside in during the year. And that's all it means. It is not a primary or principal residence. And as a result, when an agent is saying, is this your matrimonial home? They are not saying, is this what you want to be capital gains free? They're just saying, has your spouse had their underwear in this premise at any time? That's what it is. If it's a rental property exclusively, you've never had your underwear there. And thus, it is not a matrimonial home. But if spouse has lived in that property, it is a matrimonial home and subject to the matrimonial home provisions until lawyers are able to work it out with the courts. Matrimonial homes or marital homes, again, are critical because matrimonial homes are included in net family property calculations, as we discussed in the last slide. Matrimonial homes are also important because spouses have a separate right. You know the right that I was talking about at the beginning, the dower's right? The right to just keep their bum in place at a property and not move? The spouse has a right of possession to a property, which has nothing to do with the right to the money of the property and has nothing to do with putting their name on title to the property. It has to do with the idea that they can select one of their matrimonial homes and sit there bum down and not move from that property, and no one can evict them from that property absent their consent. This is the reason that you always get spousal consent on non-income properties. It's because you don't want a spouse to later say, hey, unbeknownst to you, I was actually separating and I'm espousing my spousal right here. And so while the seller has said that he can sell this, I'm not moving and there's no court in the world that can make me move. Thank you very much. This is also the reason that banks require single individuals on title to have spousal consent to the mortgage. Because that way, the mortgage, if they need to enforce a power of sale, if the spouse says, I'm separating and I have a spousal right of possession, the banks can say, you gave a priority to us over and above your spousal right of possession. That's what you signed in the mortgage. If there's a mortgage on the property, who pays as well property taxes? Jacob, I need you to explain that a bit better. So if there's a mortgage on the property, who pays that? The person who's on title. Are you saying if someone is espousing a spousal right of possession? If someone is espousing a spousal right of possession, then fundamentally it is simply the owner of the property who owes taxes, and it is the case that taxes maintain a super priority. And as a result, if you have tax liens, then even if you have a spousal right of possession, the governments are still able to take over the property. The spouse who's asserting possession will quickly understand that if taxes are not paid, they will be booted even though they don't have any legal obligation to do so. And thus they quickly come to the table and figure out a resolution to figure out how to pay off those with super priorities like municipal taxes. Okay, so this is the third exception to property. Because again, if you own property, you have the right to use that property exclusively, as no one else does. But I've just told you something different. I've told you that you do not have the right to bar entry to property or deny access to marital homes to someone who's not on.
Going around killing people.
Sorry, just have to mute that. You do not have the right to bar access to property, nor do you have right to say to your spouse, you shall not use this property, in the event that it is a matrimonial home. It is an exception to the way properties are used. All right. Oh, look at that. I have some notes here from a previous thing. I'll get rid of that. Domestic contracts. So you can opt out of what is payable on separation. So you know all this math? All of this math with the equalization payments and the matrimonial home payments and everything else, all of that is subject to negotiation either through a prenup or a postnup. It's called a prenup because it's usually done prenuptial, but it can be done a year into marriage, 2 years into marriage, doesn't matter. You can determine between the parties what is going to happen to the assets from the perspective of monies due and owing, and you can negotiate anything you want, but you cannot negotiate child support in advance. So you are allowed to say, if I get married to you, wealthy billionaire, I intend to take nothing from you upon divorce. That's perfectly valid. If I get married to you, I do not intend to claim any assets from your marital home. Note, I'm still maintaining the right of possession, but I don't intend to have that included as part of the net equalization payments. If I get married to you, I do not intend to be able to assert any spousal support claims later on. All of this is perfectly legal. The only thing that would be illegal in a prenup is basically saying, if I get married to you, I promise not to take any demand for child rearing or care. And that makes a lot of sense. Everything about family law is the best interest of the child. There is no way two people who are not married can determine what the best interests of the child are going to be upon separation, particularly given the needs that children may have, the stage of life they're at, and everything else, and the courts won't find that that's enforceable. But a prenup can pretty much deal with everything else. Make sense? Okay. Now let's talk a bit about the difference between common law and marriage, particularly for the purposes of real estate. Common law is not marriage. In fact, the entire discussion that took place in 1999 about gay rights was based on this very fact. So there is something in the Charter of Rights and Freedoms. And the Charter of Rights and Freedoms is a government document that was introduced into our legislature in 1982 and came into effect in 1985. And it basically says that as it pertains to legislation that affects individuals, equality shall be the way of the day. Section 15 deals with that equality. And while it doesn't talk about marital status was in 1999 seen to be an equivalent ground. That is to say, something equivalent to sex, something equivalent to gender, something equivalent to the enumerated names. And what happened was this. The Family Law Act, which was established before this came out, stipulated that married couples, and only married couples, could partake in this extra $90,000, the marital home, which is a significant amount because most people's primary asset is in their house. And so a couple, or one of the couples, that came out and wasn't allowed to get married before that said, thank you very much, but because I haven't been allowed to get married, I am not allowed to demand as part of equalization the property that was brought into the property because I'm not married. I'm just common law. And to that end, I am being denied fundamental rights. The government, in failing to recognize my marriage, is stopping me from actually asserting equality and equality of rights. And the Supreme Court acknowledged it. I think it was the Ontario Court actually, acknowledged it. And suddenly, gay marriage was allowed. But now there is true equality. And what true equality means is that you have the right to determine whether or not you are going to get married, which everyone now has the right to do, regardless of sexual orientation, or be common law. And that didn't change the significant differences that exist between married and common law. So married people have the right of spousal possession. Common law do not. Married people have the right to the net equalization payments. Common law people do not. Don't get me wrong, there's other recourses. They can make a claim in unjust enrichment. It's a different type of claim, but they don't have it as of right and as of statute by virtue of the Family Law Act. What's more, common law people, well, actually, I guess that's primarily what the difference is. From your perspective as real estate agents, where we see a huge distinction is largely in the land transfer tax. And people are confused because they think that if you've been married, let me back up. The Family Law Act, in a very confusing manner, defines spouse in two different ways. One is a married spouse and one is a non-married spouse. For the purposes of land transfer tax, anyone who is a spouse is determined in section, I think it's 29, which basically says someone who they have lived with for more than 3 years is deemed to be a spouse. And what's the ramification of that? Well, if you have been married to someone and while you were married to that spouse, sorry, not married, if you have been living with someone for up to 3 years, and while you have been living with that person, they have owned a property anywhere in the world, then you do not get the first-time home buyer's rebate. If you are living with someone for more than 3 years, and if they came into that relationship without property, they could have owned it in the past, but they never had it when you owned property, when you were a couple, then you as an individual can still qualify for your first-time home buyer's exemption. That is how land transfer tax works. There is a lot of confusion on this point, and so I just need to make sure everyone understands. For the purposes of land transfer tax exemptions, it's not based on whether you are actually married. It is based upon whether or not you have been living with someone for a total of, I'm not sure if it's 2 years or 3 years. I think it might be 2 years, but for a period of time. And if during that time they have owned property, you are not entitled to claim your first-time home buyer's exemption. And so this fourth exception to the family law, to the general rule of property, which says that I'm a single individual alone and I have rights that really have nothing to do with anyone else, is that your spouse or common law spouse can deny you a right to a tax benefit that you would have enjoyed if you were not married. And you should just be aware of that as well. So guys, that's it. That's how family law plays into real estate. From your perspective, what you should have taken away from this is that in the event that you are selling any property for a married couple, you must get, that isn't an income property, you must get spousal signatures on your document. It is critical, otherwise a spousal right of possession may be asserted. And you now understand that, it's actually I'll get to your question in 1 second. And you now understand that anything can be a matrimonial home where people have lived. And thus a spousal, it's not enough for them to say, yes, this is where I live and this is my cottage. You need the spousal signature on every single property where people's underwear ordinarily resides. I actually just wrote, so family law states living together for 3 years or more is common law, but the LTT common law might be less than 3 years, could be 2. Why don't they? No, that's just my mistake, actually. I honestly, it's been a year since I've actively practiced. I just reestablished my firm, and I don't remember if it's 3 years or 2 years under the definition of the Act. Whatever the definition of the Act is in Section 29 of the Family Law Act, I think it's 2 or 3 years, and I don't remember which would be the definition. They use the same definition, it's just I'm getting mixed up. Any other questions, guys? Anything else? You can unmute, you can speak, or you can type it. If not, then we had a really good session here. We had 15 participants at one time, so that's thrilling. I'm going to post this online. I hope you found this useful. I hope you found that this answered some questions. If anyone has any questions, I'm always available, of course. And of course, I thank you all for attending, as I do all the time. Terrific. Thank you. And yes, Jack, feel free to give me a call, please.